So you should be able to see our panelists again, and I will hand over to Emma Ritch. Thanks, Emma.
Thanks very much, Alice. Good afternoon, everyone, and welcome to today's webinar on the Equality Act. For those of you who don't know me and don't know Engender, I'm Emma Ritch. I'm the Executive Director of Engender, and we are a feminist policy advocacy organisation working in Scotland on women's economic, social and cultural and political equality, as well as women's rights. This webinar today is one of a series that we're holding to share our work and the work of other feminist thinkers and activists. We have a webinar next week on Polish women's reproductive rights off the back of a recent court decision to restrict women's access to abortion healthcare in breach of international human rights law, and we'll be sharing information about the whole series of webinars that we're holding in the chat bar. Some of you may know that today's session is a repeat of some in-person sessions that we ran at our Scotland's Feminist Future conference in January of this year. As with other feminist organisations across the world, Engender wants to see anti-discrimination law that works for women. And since we came into being in the early 90s, we've engaged with discrimination law review processes, including those that saw the creation of the Gender Equality Duty and the Equality Act 2010, as well as the wider feminist conversation about how the law can better respond to the injustice and discrimination that remains endemic in every area of women's lives. We also use the law to advocate for policy that better pays attention to women's lives and needs. And one of the critical questions we've been thinking about over the past few months is the extent to which equality impact assessment is working to stop women's rights rolling back as a result of the COVID-19 response. One of the biggest risks we see for women's formal equality is Brexit. The fact we've now left the European Union means the Equality Act is no longer underpinned by European law. And because equality law is mostly reserved, the threats to the Equality Act that have been consistently made by UK governments since its passage in 2010 have not yet receded. But today we're focusing on an issue that has been the subject of significant public debate over the last few years. The question about what impact, if any, reform of the 2004 Gender Recognition Act might have on the Equality Act has been covered widely, if not sometimes very well, in the media. Engender has done some work on this along with other national women's organisations, and in March we published our response to the Scottish Government's consultation on a draft bill to reform the administration of Scotland's gender recognition process. We also published On the Basis of Sex, which is Professor Nicole Busby's analysis of how these two bits of law might interact. This webinar today brings together three women with expertise on this topic. Nicole Busby is Professor of Human Rights, Equality and Justice at the University of Glasgow School of Law. She's published widely on women's labour rights, unpaid care and anti-discrimination law, and is chair of the academic reference group advising the Task Force on Human Rights Incorporation in Scotland, including CEDAW. Lynn Welsh is head of legal at the EHRC in Scotland and one of two co-leaders of the Commission's work in Scotland. And Sharon Cowan is Professor of Feminist and Queer Legal Studies at University of Edinburgh. Amid many other academic interests, she is, along with Dr. Chloe Kennedy and Professor Vanessa Munro, co-editor of the Scottish Feminist Judgments Project. And the first speaker that we'll hear from today is Nicole Busby. Nicole.
Hi everyone. I'm going to do a presentation, so I'm going to share my screen. Fingers crossed this works. Yay, it works. The relief. Okay, so let me just get this up from the beginning. Okay, so this is the presentation, or a presentation which is based on the report that Emma mentioned there in her introduction, and which I think Alice has just very helpfully shared as a link, but it was published back in, I think it was February, March, and actually I presented on that report at the Engender conference in January, And the presentation that I'm going to do today is pretty much identical to the presentation that I did then. So apologies if you were at the event in January, might be a bit repetitive. What I'm going to look at then is sex and gender reassignment under the Equality Act 2010. So I'm focusing in this work on the Equality Act and the provisions of the Equality Act. And I think that's a useful thing to do because of some of the misunderstanding, some of the confusion around what the Act actually says about sex and gender reassignment. And I will touch on the overlap or the interaction between this legislation and the Gender Recognition Act 2004 a bit later on. But I think it's important to, first of all, kind of set out what it is the Act says about these two protected characteristics. So, to start off then, by way of introduction, just what I'll do is set out the legal provisions relevant to the protection against discrimination available to individuals on the grounds of sex and gender reassignment under the Act. So looking at the left of the slide there, just a reminder that there are 9 protected characteristics covered by the Equality Act, and they're set out there. One of them is sex and one of them is gender reassignment. It would be much better if in a presentation like this, obviously, to get a really full picture of the state of the law. But to do that, we would need to give full consideration to all sources. So the Act, prior legislation, Sex Discrimination Act, statutory codes of practice, associated guidance and case law, and international law as appropriate. But there is limited time today, so I can't do all of that. The paper does, however, go into a bit more depth in terms of the relevant kind of references, citations, the different sources that we might look at here. But today I'm going to focus on the Act itself and the codes of practice and guidance that have been published under that Act. So the purpose is then to identify how or if the characteristics of sex and gender reassignment, which are both protected from discrimination under the Equality Act, interact with each other in law. And this may be helpful in informing recent debates and analyses regarding whether the protection of trans women under discrimination poses a threat to the protections currently offered under the Equality Act, including the exceptions to the general prohibition of discrimination. So the exceptions have been the subject of quite a lot of debate, and I'll go over those as well a bit later on in the presentation. So that's what I'm going to do. And so we'll start then by, this is general background, and you may be very familiar with this or not, just to look at what the Act actually does. What's the scope of the Equality Act? So it applies to services and public functions, it applies to premises, it applies to work and to education. And it sets out certain conducts which amount to unlawful discrimination, which are prohibited under the Act generally. So I've listed those on the slide here. Direct discrimination occurs when an individual is treated less favourably than a comparable person because of a protected characteristic. So you'd normally compare the person with the protected characteristic with someone who doesn't have that protected characteristic, and look at the treatment that the person has received, that the person has suffered, to see if there has been what's called unfavourable or less favourable treatment. Discrimination by association and by perception are forms of direct discrimination, and these are also covered under the Act. So there's case law actually on both of these areas, and these apply to sex and to gender reassignment. So you don't have to actually be, you don't have to have the protected characteristic in order to claim protection if you can show that your association with someone with that protected characteristic, or that you are perceived to have the protected characteristic applies. You can also claim protection against discrimination under the Act. Indirect discrimination arises where a specific policy or way of working puts people with a protected characteristic at a particular disadvantage. So this is that kind of group impact, if you like. But to claim indirect discrimination as an individual, you have to show that you've suffered a detriment. So you have to have been affected by the policy or the way of working. Harassment is also covered. This is where an individual is made to feel humiliated, offended or degraded because of a protected characteristic. And then there's victimisation, which is where someone is treated unfavourably because they've made a complaint of discrimination under the Act, or they've supported or they are supporting someone who has made a complaint. So it kind of gives that protection and ensures, as far as possible, access to justice, and that you don't suffer victimisation because you're claiming a right under the Equality Act. So that's a very brief run through. I'll come back to some of these areas, maybe not all of them, but some of them as I go through the rest of the presentation. Let's focus first of all then on the protected characteristic of sex, which is provided for specifically under the Act. So section 11, you see on the left of the slide there, provides in relation to the protected characteristic of sex, it's a reference to a person who has a particular protected characteristic is a reference to a man or to a woman. And a reference to persons who share a protected characteristic is a reference to persons of the same sex. So the term sex rather than gender is used throughout the Act in relation to the specific protected characteristic. There's one exception, which are the provisions relating to the requirement for employers to publish information relating to differences in pay between men and women, which is referred to as the gender pay gap or gender pay gap information. So gender is used there. Rightly, you know, I can come back to that. I won't come back actually to gender pay gap specifically, because not really relevant to what we're talking about today, but that's where gender is used. Otherwise, the Act refers to sex. Now, on the right of the slide, you'll see that I put up section 212, because this provides further guidance in interpretation. So what does woman mean? What does man mean under the Act? There's a bit more guidance in interpretation here. Woman means a female of any age, it says, and man means a male of any age. Don't know how helpful that is, because there's no further definitions of the term male or female provided in the Act itself. So the question then that arises is, are the Act's provisions on sex discrimination intended to be applied on the basis of biology or on the basis of gender roles or stereotypes? Well, I would say that the preservation, of the use of both terms, sex and gender, is important in relation to women's rights. Very important. So if we restrict the restriction of the definition of sex to a purely biologically determined status would result in a narrower application of the Act, which could result in a lower level of protection on the ground of sex discrimination. Looking for sort of further guidance on this, the Statutory Code of Practice does draw a distinction between an individual's birth sex and her reassigned sex, but it only does this when it refers to the protected characteristic of gender reassignment, which I'm going to come on to in a moment. So the purpose of the inclusion of sex as a protected characteristic, I think, goes without saying. Of course, it should be in there. But the law recognises, I think, the Act recognises that women require protection against discrimination on the grounds of both their biological difference from men and the social construction of gender, which influences social norms and individual and household behaviours, because women's lived experience, as we know, is different from that of men's. Why do I say that if we just apply a purely biological status, we'd have this narrow application which could result in a lower level of protection? Well, an example arises under indirect discrimination. So a claim of indirect discrimination could be used to challenge the imposition of age restrictions that unfairly exclude a woman from applying for certain jobs. So this is quite a on the face of it, quite a neutral provision. Candidates should be under 28 years of age to qualify for this job. But because of a woman's absence from the labour market for a number of years due to childcare commitments, she might be excluded from that provision. And the law on indirect discrimination does recognise that. We also use gender to challenge gender stereotyping, so a form of direct discrimination. For example, a mixed sex school which restricts cookery classes to girls only on the basis that as women they will be responsible for cooking within households. May or may not be true in our own lives, but certainly we want to challenge those gender stereotypes And that broad definition, where we're not just relying on biological difference, there's no biological reason why women might be better or expected to do more of the cooking in a household. It's a gender stereotype that leads to that kind of assumption. And we want to challenge those, and the Act does enable us to do that. Turning then to the protected characteristic of gender reassignment. Now, looking then at section 7, which is on the left hand of the slide, the Equality Act provides that a person has the protected characteristic of gender reassignment if the person is proposing to undergo, is undergoing, or has undergone a process or part of a process for the purposes of reassigning the person's sex by changing physiological or other attributes of sex. So the Act doesn't refer to the need for the process of reassigning sex to take place under medical supervision. It provides protection to trans people, and gender reassignment is the language used in the Act. It doesn't talk about trans people or trans men or women. It talks about gender reassignment as the protected characteristic. But it provides protection to trans people under against direct and indirect discrimination, harassment and victimisation. So under section 7, as we see from the wording there, a trans person is to be treated as having the gender identity which the individual proposes to be, or which has or is being assigned as a full or partial process. So self-identification will enable an individual to claim protection under the Equality Act on the grounds of the protected characteristic of gender reassignment without the need to acquire a gender recognition certificate under the Gender Recognition Act 2004. The Code of Practice on Services provides guidance. It specifies that the reassignment of a person's sex may be proposed but never gone through. The person may be in the process of reassigning their sex, or the process may have happened previously. It may include undergoing the medical gender reassignment treatments, but it does not require someone to undergo medical treatment in order to be protected. There's generally broad coverage for the protection of gender reassignment across all fields. One exception is the prohibition of harassment under section 26. This doesn't apply to gender reassignment in the context of school education. So in such cases, you'd have to base a claim on the ground of direct discrimination rather than the freestanding ground of harassment. So we see there is difference there between then the provisions of the Equality Act and the provisions of the Gender Recognition Act. So let's just have a look at the interaction between the two. Left of the slide then, section 9 of the GRA 2004 Act provides that where a full gender recognition certificate is issued to a person, the person's gender becomes for all purposes the acquired gender. So that if the acquired gender is the male gender, the person's sex becomes that of a man, and if it's the female gender, the person's sex becomes that of a woman. So the Act provides two processes by which trans people aged 18 and over can apply for a gender recognition certificate, either on the basis that they are living in the other gender or that they have changed gender under the law of another country. And in order to fulfill that requirement of living under another gender, to get a gender recognition certificate, a gender recognition panel, usually comprised of 3 legal and medical experts, will be responsible for assessing that an applicant has, for the certificate, meets certain specified criteria. This will include a diagnosis of gender dysphoria, evidence of having lived in their acquired sex for at least 2 years, and an intention to continue to live in the acquired sex until death. So the interaction then between the two pieces of legislation, they applied different approaches to the issue of identification of trans status. Another distinction relates to the issue of age. The minimum age for legal gender recognition under the GRA is 18, which is aligned with the age at which full rights and responsibilities relating to adult citizenship will apply. As government guidance highlights, this mirrors the age at which trans people can access surgical treatment through the NHS. there's no intention to change the GRA age restriction at the UK level. In line with the self-identification approach, however, the Equality Act imposes no such age requirement on an individual's claiming trans status. So the Equality Act's self-identification approach does pose certain questions regarding the operation of the exceptions to the principles of equality and non-discrimination provided by the Act. So I spoke about the prohibition of discrimination at the beginning and showed you all those different definitions of what discrimination might look like, but there are some exceptions to those prohibitions. In other words, there are some circumstances in which discrimination will be lawful under the Act. And we'll turn to those now and look at the relevant Equality Act exceptions. So the Act contains exceptions which allow for some forms of discrimination in certain situations. And there are two relevant exceptions which have the potential to be applied in circumstances involving trans individuals. One is the exception concerning the provision of separate or different and single-sex services, and the other is a general exception which relates to communal accommodation and associated benefits, facilities and services. So I'm going to run through each one in turn. So here's the first one, that exception which is to do with the provision of separate or different and single-sex services. So this is a service exception. Schedule 3, Part 7 provides a person does not contravene Section 29. Section 29 prohibits discrimination in the provision of services. So far as relating to gender reassignment discrimination only because of something or anything done, in relation to a matter within subparagraph 2, if the conduct in question is a proportionate means of achieving a legitimate aim. I'll come back to that in a moment. That's really significant. It's really important here. So this relates to services and public functions. The relevant matters are the provision of separate services for persons of each sex, provision of separate services differently for persons of each sex, the provision of service only to persons of one sex. So it allows those who provide separate or single-sex services to provide a different service to, or to exclude someone who has the protected characteristic of gender reassignment in certain circumstances. There must be that proportionate means of achieving a legitimate aim. This is a general test, an established test in discrimination law and human rights law. It's commonly used to justify behaviours or impacts which on their face are discriminatory. It's known as the proportionality test, and I'll come back to it in a bit more detail in a moment. So what does this mean in practice? This includes those who have a gender recognition certificate, as well as those who do not have a gender recognition certificate, but otherwise meet the definition under the Equality Act, as long as the action taken is that proportionate means of achieving a legitimate aim, which I'll come back to. What can we find from the guidance attached to the Act that might help us here? The example given in the explanatory notes of when separate services may be provided for one sex which excludes trans people is a counselling service for vulnerable women, where service users may refuse to attend sessions if trans women are permitted to attend. So that's the example given in the explanatory notes. The Code of Practice provides the example of a single-sex changing room in a clothes shop, in which the exclusion of trans people would not be proportionate if there was separate individual cubicles. So where there is the availability of separate individual cubicles, it won't meet that requirement of a proportionate means of achieving a legitimate aim in those circumstances, because privacy is maintained, if you like. We'll turn then to the general exception, which relates to, remember, communal accommodation and associated benefits, facilities and services. This is covered under Schedule 3, which provides person does not contravene the Act relating to sex discrimination or gender reassignment discrimination because of anything done in relation to the admission of persons to communal accommodation and the provision of a benefit, facility or service linked to that accommodation. So this exception allows a service provider to exclude a trans person from communal accommodation and to refuse services connected to providing that accommodation on the grounds of sex or gender reassignment in certain circumstances. Again, that proportionality test will apply, which I'll come to in a moment. This aligns the provisions of communal accommodation with the provision of separate or single-sex services, because in order to justify either exception, that proportionality test has to be satisfied. To give a bit more detail, a bit more meat, if you like, on the bones, the Code of Practice on Services does give a bit more guidance here. It says this must be considered on a case-by-case basis. In each case, the provider of communal accommodation must assess whether it is proportionate to exclude the transsexual person. The explanatory note states that the exception allows communal accommodation to be restricted to one sex only, as long as the accommodation is managed as fairly as possible for both men and women. The explanatory notes don't provide any specific examples of how this exception might apply in cases involving the exclusion of trans individuals from shared accommodation or related benefits, facilities or services. So no specific examples are given as to when this may apply, this particular exception. Looking then at the proportionality test that I mentioned, which is really critical here, if we're using that case-by-case approach, which we're told we should be using, we then have to really understand what the proportionality test means and how to apply it, when it will apply, and what will be determined by the application. And there's more guidance given here in the Code of Practice. So it says if a service provider, left of the slide, provides single or separate sex services, they should treat transsexual people according to the gender role in which they present. Exclusion will only be lawful where it is a proportionate means of achieving a legitimate aim, so that proportionality test. The intention is to ensure that the transsexual person is treated in a way that best meets their needs. Service providers need to be aware that transsexual people may need access to services relating to their birth sex. So this suggests that to comply with the proportionality test, the service provider will need to take full account of the self-identification, remember, which is permissible under the Act, and related needs of the trans individual when making a decision to exclude. The service provider should therefore take account of whether and how far it's reasonably reasonable to expect that the accommodation should be altered or extended, or that further accommodation should be provided, and the relative frequency of demand or need for the accommodation by persons of each sex. This places the onus on the service provider to consider the provision of suitable alternatives to shared accommodation before reaching a decision to exclude. So you can't just make a blanket exclusion, you've got to look at the circumstances that are relevant. In reference to the exclusion of a trans person from shared accommodation under Schedule 3, the Code of Practice on Services provides that there is any exclusion amounts to a proportionate means of achieving a legitimate aim. When excluding a person because of sex or gender reassignment, the service provider should take account of the things that I've listed on the slide there. Alternatives might include, so the sorts of things you might look at in seeking alternatives would be the provision of single user facilities, separate cubicles, or gender neutral facilities where that is a relevant alternative. What we know about the proportionality test from other areas of discrimination law is that the threshold required to meet this test is high, generally. We know that from the case law. In the current context, for example, it looks likely that it would require the production of robust data or other evidence to support claims made regarding the potentially negative consequences for other users arising from a trans woman, for example, accessing a single-sex service or shared accommodation. So you really need to be able to show that there is data, evidence. It's got to be evidence-based is what we're looking for here in order to meet that threshold of the proportionality test. Reliance, for example, on an assumption that other service users may object to such access will not generally meet the threshold. So you can't just say, oh, we're assuming that people are going to be unhappy with this. You need to show that that is backed up by data or evidence. If making a claim that introducing a trans person to the service would impact on the effectiveness of the service, For example, through a significant drop in the numbers of those using the service provider would be required to provide evidence of the negative impact claimed. In such circumstances, exclusion would be based on the impact on the service and not on the individual's trans status. That's important. So you're showing that the service is going to cease to be useful to the individuals or the populations that it is provided for. It's not because we wish to just exclude someone on their trans status. So it's quite a high threshold actually to meet in practice. So that's, sorry, a quick whistle stop tour, very quick in some cases, but as I say, there's more detail in the report, so do look at that if you haven't done already. And I'm just going to end with some concluding thoughts and observations. These are sort of personal thoughts and observations that I had when I was looking at the area in preparing that report. And I'll just run through those fairly quickly and then I'll finish up. So I would say that the Act is fairly clear and comprehensive, although it is by no means perfect, not just in this area, but in lots of other areas. No means perfect, but it's, you know, there's clarity there in most respects. It's important to take an inclusive approach by providing adequate protection against discrimination on the grounds of both sex and trans status for the reasons that I've given, to ensure continued interpretation aligns with progressive social norms and to provide a dynamic legal framework. I would say that consideration should be given to the following things, and that it's not an exhaustive list, it's just some of the main issues that I sort of picked up when I was looking at the area. Sorry, somebody, that's my bell, my buzzer going. It's okay, someone else has gone to get that. Quite an aggressive ring on the bell there, don't know who it is. Right, so what are the things that I think attention should be given to? First of all, updated terminology. So the Act and the terminology used in the Act could be updated, I think, and that would probably add some clarity. This applies to the Act and the accompanying guidance. It could be amended, for example, to clarify the available protection of trans, non-binary and intersex identities under its provisions, along with some clarification around appropriate non-restrictive definitions. That might be helpful in some respects. Updated and more specific guidance could be included in the relevant codes of practice. The Equality and Human Rights Commission and the Women and Equality Committee of the UK government, Parliament, sorry, have articulated the need to improve the definitions relating to gender identities under the Act. So that has been noted. Definitions of sex and gender could be clarified. Perhaps that might be helpful, although we want to be non-restrictive there for reasons that I mentioned at the beginning. So I think careful regard would have to be given to ensure no reduction in the levels of protection against discrimination applicable to women in respect of both their biological difference from men and in regard to gender roles and stereotypes, while obviously clarifying and perhaps strengthening the protections afforded to trans people. What else? The Act's application and interpretation. There is a dearth of decided case law or attempted litigation, which demonstrates the Act's failure to either to provide adequate safeguards for non-trans users or you know, people who aren't trans of relevant services, or to include trans users or trans people in the provision of services. I think there could be tightening up there. Research exploring the reasons for the lack of case law could be extremely helpful. Why haven't we got these test cases coming through? What are the nature and extent of these unlitigated issues that exist? And this might provide the basis for recommendations for amendments to the legislation. And it might also help in identifying strategic litigation. So there's some work that could be done there in terms of research. And then moving towards the guidance and the statutory codes of practice, the current guidance and codes of practice could benefit from updating in lots of ways. The lack of clarification on some key issues means that public bodies, the women's sector organisations and legal advisors may be applying contradictory approaches and providing conflicting advice to those directly affected. And so review and revision of the guidance would enhance legal certainty, I think, in this area. But I do recognise in saying that the statutory nature of the codes of practice mean that such changes are dependent on political will and are subject, obviously, to the time constraints of legislative reforms. I'm going to finish there, but thank you very much for your attention. As I say, more detail in the report if you haven't looked at that. Thank you.
Thanks so much, Nicole. That was extremely interesting and helpful. Can I move straight to Lynn Welsh from the Equality and Human Rights Commission, Lynn, and just ask you to respond to that and update us on any work that the Commission's doing in this?
Yeah. Hi, everyone. Good to be here with you today. I'll try and keep this very short so that there's still time for questions at the end. For those of you who don't know us, the Equality and Human Rights Commission is Britain's national equality body, and we also have a human rights remit, which in Scotland we share with the Scottish Human Rights Commission. In this particular area, we have used a number of our powers and our duties, I guess, in relation to our work on the Equality Act. So it's our job to keep the Act under review, to see how it is working, to promote understanding of it where we can do that, including through our guidance, and to encourage good practice in relation to how it's working. In relation to our work around consultations, we also have responded to the Gender Recognition Act consultations in both England and in Scotland, and are supportive of those changes that are going through. Our guidance, Nicole has suggested, could do with an update. That is something that we've heard from more than one area, and I think that we do try to keep all of our guidance under review as far as we're able to do it with the resources that we've got. But absolutely, we will keep looking at whether we can improve that. I agree with you that the lack of litigation, not that I would say everything should leap to litigation, but I think in this particular area, it does make a full understanding, if you like, of how the legislation works difficult when it's not being tested, and makes it, I suppose, gives us an extra hurdle to think about when we're looking at our guidance as well. And because of that, we do look at using our enforcement and our litigation powers in this area. So we are able to support individuals in taking cases under the Equality Act, and we can also take enforcement action and litigation in our own name. And we are interested in doing that where cases might start to help us answer some of the questions or the areas that some may think are unclear in relation to the Equality Act. So that is something we very much have on our radar at the moment, using our own powers to try and bring some clarity around some of the issues in this area. We also, I guess, as a human rights body, are keen to try and encourage our sort of good relations mandate in this area to have open, respectful dialogue where we can manage to assist that in happening, I guess, a bit like today's event, where we can bring bodies together or different views together and have that respectful discussion. And that's also an area that we think we need to do a bit of work in going forward. I'll leave it there, Emma, if that's okay. Happy to look at questions, but I want to give time to Sharon, obviously, to cover.
That's terrific. Thanks so much, Lynn. Sharon.
Thanks, Emma. Can you hear me? Awesome, thank you. Thanks, Nicole and Lynn, and nice to see you again after the event in January. I am coming at this from the perspective of having worked for a long time with trans people on specifically on the impact of equality law on them doing ethnographic work, but I'm also coming at it from the point of view of trying to also understand the application of the Equality Act in relation to gender reassignment, given that, as you both said, there's a lack of case law in the area that tests out the parameters of the law. And I think that that is one of the main issues here, which is what causes quite a lot of anxiety and confusion, is that there doesn't seem to be a very clear set of guidelines coming out of cases that show in specific examples how the courts will apply the Equality Act. So although there are some examples given in the guidance, not having those scenarios tested out through case law is I think one of the things that generates anxiety and confusion for people. But I would also echo Nicole's suggestion that the Equality Act be interpreted in as inclusive and enabling way as possible in its protections, and that when you're weighing up what look like competing protections, may or may not be competing protections, but when we're weighing those up, to be doing that in a way that is in line with our human rights commitments, as well as a number of other principles. So I was thinking primarily about what Nicole was saying about proportionality in relation to the exceptions, and the idea that you have to have a proportionate and legitimate aim to exclude under the exceptions. And I think what I would say there is that although, again, there's not really any case law that tests out what proportionality means in practice in this area, specifically, there is a lot of litigation and other sorts of guidance on what proportionality means just generally in law. And we don't have to look any further than Article 8 of the Human Rights Act, which protects private and family life, but that's not an absolute right. It's a right that is subject to being overridden if there's a proportionate legitimate aim. So there's a lot of litigation around that interprets what proportionate means when two sets of what look like competing rights are at play. And there's also, as Nicole said, proportionality case law in relation to other aspects of the Equality Act that don't pertain to sex and gender reassignment. So I think it's really helpful to look at those areas and to get an understanding of what we mean by proportionality and what we mean by legitimate aim and so on. But in practice, it would be very helpful to have some strategic litigation to flesh out those areas in more detail. The only thing that I wanted to add, which I think probably opens up another conversation altogether with the Equality Act, is just about how law in general responds to difficult questions, and particularly here about the questions of sex and gender reassignment. And one of the questions is about terminology. And if you work in this area, you know that terminology and meanings of terminology have changed quite a lot over time, especially in relation to the transgender community, but also in relation to what sex means and what gender means. And law has been sometimes slow to take up the changes in society around what we understand by those terms. There would have been, many decades, if not hundreds of years, where the word gender would not have been used. We wouldn't have understood what we meant by gender roles and expectations because the law only used the word sex for a long time. And using the word gender in relation to gender discrimination is a really important, as Nicole said, a really important aspect of thinking about the protected characteristic of sex under the Equality Act, because we've long read in that idea of gender discrimination into sex discrimination. So just to say that the law in this area is sometimes a bit slow to catch up with changing norms and different sort of social meanings and terminology, but that we have to keep that kind of flexibility and what Nicole called a dynamic legal framework in mind when we're thinking about how to address really difficult questions about around how we see and define and operationalise terms like sex and gender reassignment. And I think I'll just leave it there as well.